Please subscribe to the channel to watch the latest videos.
Ivanka Trump testifies in New York fraud case against family business. New York, Ivanka Trump testified Wednesday of limited awareness of financial statements central to a civil trial accusing her father, two of her brothers, and their namesake business of fraud, capping off a striking stretch that saw 4 members of the family questioned under oath. Like her brothers, who testified last week, Ivanka Trump spent her time on the witness stand at New York State Supreme Court, distancing herself from the financial documents at the heart of the case brought by New York Attorney General Letitia James, Democrat. In a lawsuit last year, James accused former President Donald Trump and his company of knowingly inflating the value of assets in financial statements submitted to banks and insurance companies to secure better terms. James is seeking the recovery of at least $250 million in allegedly ill-gotten gains and has asked New York Supreme Court Justice Arthur Engoron to impose severe restrictions on how the Trump Organization can operate in the state. Because this is a civil case, none of the defendants face potential prison time. Ivanka Trump was asked during her testimony by a member of James's team about a Trump Park Avenue lease that she had with her husband, Jared Kushner, and pressed on whether it was improperly accounted for on one of her father's financial statements. As I had told you a year and a half ago, I wasn't involved in this financial statement, so I can't say what it took into account or didn't take into account, said Trump, who left the company in 2017 to serve as a White House advisor during her father's term in office. She testified that she was aware that her father had financial statements prepared but could not speak to how they were compiled. Trump's time on the stand was a marked contrast to her father's own testimony 2 days earlier. When he testified Monday, the senior Trump was animated and agitated, criticizing the judge and James's lawsuit. Ivanka Trump, by comparison, remained calm and polite throughout. Unlike her father and 2 adult brothers, she is no longer a defendant in the case. She had been initially named as one, but an appellate court dismissed the claims against her in June. Her testimony covered the key role she played in major Trump Organization transactions, including the acquisition of the landmark Old Post Office Pavilion in D.C. The Trumps leased it from the General Services Administration, GSA, and they operated a hotel there that served as a pivotal hub for events and people orbiting the family throughout Trump's term in office. Lawyers with the State Attorney General's office presented a 2011 letter from the GSA that highlighted the agency's concerns with the Trump financial statement. The document was provided to show his worthiness to develop and manage a luxury hotel in the historic structure in downtown Washington. The GSA's letter said the financial statement from Trump departed from generally accepted accounting rules and did not account for income tax liabilities. Ivanka Trump testified that she was in the loop on discussions about addressing the GSA's concerns, but said she didn't remember specifically how the issue was handled. She repeatedly said her memory had been jogged in many cases by the Attorney General's documents. She also spoke about recalling one in-person meeting with the GSA that was held in Washington, primarily to discuss the Trump Organization's plans for the old post office's renovations. The meeting was not about financial statements or anything granular like that, but a big-picture discussion of the vision and our experience from a construction perspective, she said. When questioned by attorneys for the Trump side, Ivanka Trump discussed the praise that she and her father received from their contacts at Deutsche Bank, which issued loans to them that the Attorney General has said were obtained improperly. She expressed tremendous excitement to have our account, Ivanka Trump said, referring to her Deutsche Bank banker, Rosemary Vrablic. After her testimony concluded Wednesday afternoon, James's side they were resting their case, with the caveat that they could again call Allen Weisselberg, who had been the longtime top financial officer of the Trump Organization. They also could put on a rebuttal case after Trump's side calls its own witnesses. At day's end, meanwhile, attorneys for the Trump side said they planned to argue Thursday to have the case decided in their favor. James's office said it planned to argue against letting some of the Trump side's witnesses take the stand. Attorneys for Trump are expected to begin calling their witnesses Monday. Trump's side has said no fraud took place, nothing illegal happened, and there were no victims. The trial has cast an ongoing spotlight on the Trump family and their businesses, something that has visibly irritated Donald Trump. While under no obligation to show up in person before his testimony, Trump has attended the proceedings multiple times and been intensely critical of the case on his way in and out of the courtroom. Trump, a Republican, is seeking another term in office and has said this lawsuit and the 4 criminal cases against him are all politically motivated. Engoron ruled before the trial that Trump and his company broadly committed fraud. Now the state justice is hearing the case without a jury and will determine any potential penalties. The courtroom atmosphere Wednesday was much less charged than it was Monday, when Trump testified for much of the day and clashed with Engoron. Trump criticized the judge's pretrial ruling and complained that it was a very unfair trial. Engoron told the former president to refrain from extraneous comments and urged one of Trump's attorneys to control your client. Trump also said that the statements of financial condition at issue in the case were actually downplaying his true net worth and that banks were served with a disclaimer on his statements that invited them to conduct their own financial analyses of the company. The trial paused Tuesday for Election Day, making Ivanka Trump the first witness called after her father. Berman reported from Washington. As Democrats prepare to subpoena Thomas Alito allies, one benefactor cooperates. A new effort to wrest information from conservative allies of Supreme Court justices will probably be blocked by Senate Republicans. For months, Democrats in Congress have tried unsuccessfully to press the Supreme Court to strengthen its ethics rules, following revelations that some justices accepted, and did not report, free luxury travel, real estate deals and gifts from wealthy benefactors. Now, Senate Democrats see an opening to demand more details about the extent of the largesse, details they say would inform their legislative efforts to impose more stringent ethics requirements on the High Court. The Senate Judiciary Committee plans to vote Thursday to subpoena a wealthy benefactor, along with a judicial activist who helped shape the conservative supermajority that has quickly moved the court's jurisprudence to the right. The subpoenas will demand a list of all transportation, lodging, gifts and access to private clubs provided to any justices and their relatives. On Wednesday, Chairman Richard J. Durbin, Democrat, Illinois, announced he was dropping plans to subpoena a third person, Robin Arkley II, after the California businessman provided the information the committee was seeking. Arkley's attorney, Samuel E. Clark, confirmed the cooperation and said, "We don't agree it's public information, but we were treated fairly." The other 2 targets, activist Leonard Leo and Texas billionaire Harlan Crow, have pushed back aggressively against the Democrats' demands, defending not just themselves, but also Justices Clarence Thomas and Samuel A. Alito Jr. in lengthy letters citing past Supreme Court cases. Lawyers for Crow and Leo say the committee's requests are overly invasive, exceed the panel's authority, and are driven by politics, rather than a legitimate need for information to pass legislation. This inquiry appears calculated to target and intimidate Justice Thomas by unearthing details about his private life that the committee evidently believes will embarrass him and inflict public humiliation, Crow's attorney, Michael D. Bopp, wrote in a 7-page letter last month. Without Republican support in the Senate, the subpoenas may prove difficult to enforce, despite Congress's well-established, broad power to investigate. Senator Lindsey O. Graham of South Carolina, the committee's ranking Republican, told Democrats to stay out of the business of the Supreme Court, an independent branch of government, and vowed that his party would block the subpoena effort. "You have lost your way," Graham said of the Democrats' plans during a committee hearing. "I don't know why you did this." But Durbin is pushing ahead with demands for more information. Leo has refused to voluntarily provide the information over the last several months, while Crow offered to turn over a limited set of information that lawmakers said was insufficient. They are not bit players in this crisis, and the information they hold is critical to understanding how individuals and groups with business before the court gain private access to the justices, Durbin said in a statement. Sparring over ethics. Under federal ethics law, top government officials from all branches of government, including Supreme Court justices, are required to file annual financial disclosures listing investments, gifts and outside income. Democrats and court transparency advocates have criticized the High Court for lacking a binding ethics code specific to the 9 justices and are pressing for disclosure rules as strict as those that apply to members of Congress. Scrutiny of the justices' activities off the bench intensified after ProPublica reported extensively on Thomas's failure over many years to disclose in his annual reports free luxury vacations and private jet travel he received from Crow, his longtime friend. Thomas also did not initially report Crow's purchase of 3 properties from Thomas and his relatives, or that Crow paid the boarding school tuition for Thomas's great-nephew, of whom Thomas had legal custody. The investigative news site also revealed that Leo arranged for Alito to take a luxury fishing trip to Alaska in 2008 that included free lodging and private jet travel. The lodging, according to the ProPublica report, was provided by Arkley. Both Thomas and Alito have said they did not think they were required to report the trips in annual disclosure forms. After ethics rules were revised in March, making clear that judges and justices must report private jet travel, Thomas disclosed 3 2022 trips on Crow's jet. He also for the first time listed the 2014 real estate sale to Crow, a transaction that most ethics experts said should have been reported long ago. Thursday's planned Senate committee vote on the subpoenas is the most aggressive step Democrats have taken so far to pressure the High Court to adopt a stronger set of ethics and recusal rules. In April, Chief Justice John G. Roberts Jr., who has opposed intervention by Congress, turned down an invitation from Durbin to testify about Supreme Court ethics before the committee, saying it would not be appropriate for the head of an independent branch of government. Alito separately took the unusual step over the summer of publicly commenting on the validity of legislation to impose an ethics code on the court. "I know this is a controversial view, but I'm willing to say it," Alito said in an interview with the Wall Street Journal editorial page. "No provision in the Constitution gives them the authority to regulate the Supreme Court, period." Roberts and 3 other justices, Elena Kagan, Brett M. Kavanaugh and Amy Coney Barrett, have suggested that the justices should adopt their own ethics policy. But past efforts to reach agreement have failed. In 2019, Kagan told a congressional committee that Roberts was seriously studying the issue. In July, the Judiciary Committee advanced legislation that would require the High Court to adopt an ethics code, create a system for investigating alleged violations of that code, and require justices to publicly explain recusal decisions. The bill lacks the bipartisan support necessary to clear the full Senate and would probably stall in the GOP-controlled House. Separately, Democrats sent letters in May and July seeking extensive information from Crow, Leo, Arkley, and other entities connected to the justices' travel. Lawyers for Crow and Leo opposed the requests, invoking arguments similar to those made by then-President Donald Trump when he was fighting congressional subpoenas for his tax and financial information. Trump claimed the subpoenas served no valid legislative purpose and were politically motivated. His argument was rejected by the Supreme Court, although Thomas and Alito dissented, with Thomas taking the view that Congress has no power to issue a legislative subpoena for private, non-official documents, whether they belong to the president or not. No other justice joined Thomas. In their letters last month, lawyers for Crow and Leo similarly said there is no lawful basis for the committee's investigation because Congress has no authority to regulate the Supreme Court, and therefore the underlying proposed legislation would be unconstitutional. Crow and Leo accuse the committee of targeting Alito and Thomas instead of more broadly examining events attended by other justices at elite law schools or sponsored by liberal legal organizations. If the committee were actually pursuing the inquiry it claims, these frequent trips and events would be of at least as much interest to the committee as a fishing excursion Mr. Leo took with Justice Alito 15 years ago, wrote Leo's lawyer David B. Rivkin Jr., who also co-wrote the Wall Street Journal article in which Alito expressed his dim view of the ethics legislation. But former congressional lawyers say the committee's power to subpoena is clear. Between 2000 and 2019, the panel subpoenaed 10 individuals in 4 matters. If it can legislate, it can investigate, said Douglas Letter, the former general counsel to the House of Representatives who defended Congress's authority in legal battles with Trump. Even if there are constitutional limits, Congress gets to voice a view on what the proper limits are, he said. Lisa Graves, a former chief counsel to the Judiciary Committee, agreed that the committee is carrying out its responsibility to engage in fact-finding to help create better laws. What is unusual, she said, is the resistance to what is certainly within the jurisdiction of the Judiciary Committee by some very powerful people who are asserting extraordinary arguments to try to win in the public arena. Republican opposition. Graves, executive director of the watchdog group True North Research, said the Senate process is likely to be a hurdle for Democrats because Republicans will probably use every tool available to stop this investigation from going forward. The vote to authorize the subpoenas requires a simple majority of the committee, meaning no Republican votes are needed. If the subjects do not comply, Democrats have two options. The Senate can seek civil enforcement of the subpoenas in court. That step requires a vote of the full Senate and would probably stall in the face of resistance from Republicans, who have dismissed the scrutiny of the justices as an effort to undermine the court's conservative supermajority. Or, the Senate could refer any failure to comply with a subpoena to the Justice Department for possible prosecution. The House voted last year to hold several Trump advisors in criminal contempt of Congress for defying subpoenas from the committee investigating the January 6, 2021, attack on the Capitol. Those votes, mostly along party lines, sent the matter to the Justice Department. The Justice Department opted to pursue cases against former Trump advisor Stephen K. Bannon and former White House trade advisor Peter Navarro, both of whom were found guilty of contempt. But they did not charge former Trump White House Chief of Staff Mark Meadows or Communications Chief Daniel Scavino Jr. Alex Aronson, a former chief counsel to Senator Sheldon Whitehouse, Democrat, Rhode Island, and court accountability advocate, said there is nothing in the statute that requires a full Senate vote to make the referral to the Justice Department, although that has historically been the practice on the House side. Under prevailing norms, criminal contempt certifications do typically include a vote of the full chamber, he said. But ultimately, as a statutory legal matter, there is nothing in the statute that requires that full Senate vote. The subpoena plan, he added, raises important questions about the role of congressional precedents and norms in the post-Trump era, after Republicans appended so many settled bipartisan norms so they could act unilaterally, particularly in the Judiciary Committee. During the committee's hearing last week that touched on the Democrat subpoena plans, Graham, the ranking Republican, was clear, "You know you're not going to get 60 votes to enforce the subpoena," he said. "This is a fight you wanted. You're going to get it." Court seems likely to allow gun bans for those under protective orders. The Supreme Court on Tuesday appeared likely to uphold a federal statute disarming people who are subject to domestic violence protective orders, signaling a reluctance to make that issue the next frontier in the court's recent efforts to expand Second Amendment rights. Justices on both sides of the court's ideological divide seem to think the Constitution does not prohibit legislatures from restricting firearm possession among individuals who are found to be a danger. During oral arguments Tuesday morning, some of the justices suggested they did not have to go much further than that to decide the case at hand. The backdrop was fallout from the court's 2022 decision in New York State Rifle and Pistol Association v. Bruin, which requires the government to point to historical analogs when defending laws that limit Second Amendment rights. Solicitor General Elizabeth B. Prelogar, representing the Biden administration, said the U.S. Court of Appeals for the Fifth Circuit, considering a Texas man arrested for possessing guns after a state court had imposed a restraining order, had profoundly erred in finding that a federal law meant to protect victims of domestic abuse was unconstitutional. The law, Prelogar said, satisfies both the Constitution and common sense. Throughout our nation's history, legislatures have disarmed those who have committed serious criminal conduct or whose access to guns poses a danger, for example, loyalists, rebels, minors, individuals with mental illness, felons, and drug addicts, Prelogar said. There is no historical evidence that those laws were thought to violate the right to keep and bear arms. She said the Fifth Circuit's opinion was part of a profound misreading that many lower courts have been adopting in trying to apply the Bruin decision to gun restrictions across the country. Only Justices Clarence Thomas and Samuel A. Alito Jr. closely questioned Prelogar's defense of the law. But it was unclear whether the justices had an appetite for broadly clarifying a test they imposed just last year, or were looking for a narrow way to resolve the issue at hand. The challenge to the domestic violence order restrictions was brought by Zaki Rahimi, a drug dealer who was placed under a restraining order after a 2019 argument with his girlfriend in a parking lot turned violent. According to court records, Rahimi knocked the woman to the ground, dragged her back to his car, picked her up and pushed her inside and fired a shot at a bystander. The girlfriend escaped, but Rahimi later called her and threatened to shoot her if she told anyone about the assault. A Texas court found that Rahimi had committed family violence and that such violence was likely to occur again in the future. It issued a protective order that suspended his gun license, prohibited him from having guns, and warned him that possessing a firearm while the order remained in effect might be a federal felony. Rahimi continued to fire guns in public in a series of events. In early 2021, Rahimi was arrested at his Texas home, and police found a .45 caliber pistol, a .308 caliber rifle, magazines, ammunition, and a copy of the protective order, the government said in its brief. He was charged with illegally possessing a weapon. Rahimi said his right to a gun was protected by the Second Amendment. After a judge ruled against him on that issue, he pleaded guilty to the federal charge and received a sentence of 6 years in prison. He continued to challenge the law, and the Fifth Circuit reheard his case after Bruin was decided. In Bruin, the justices voted 6-3 to strike down a century-old New York state law requiring a special need to carry a firearm outside the home. Thomas, writing for the majority, said government officials cannot justify restrictions on firearms based solely on an important interest such as public safety concerns. Instead, he wrote, officials must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. The analogy does not have to be a twin, the court ruled, but must be relevant. Courts should not uphold every modern law that remotely resembles a historical analog, because doing so risks endorsing outliers that our ancestors would never have accepted, Thomas wrote. The unanimous Fifth Circuit panel found Rahimi was among those whose right to a weapon is protected by the Second Amendment. It rejected the historical comparisons advanced by the government to justify the law barring those with protective orders from possessing guns. Federal Public Defender J. Matthew Wright, representing Rahimi, said the Fifth Circuit got it right, and laws written before the Supreme Court found a Second Amendment right to possess a firearm in the home for protection, including the federal statute Rahimi was found to have violated, were suspect. Referring to his client, Wright said this is someone who's keeping a gun in his home. The restriction on gun possession by those subject to domestic violence protection orders is a total ban, he said. And it is punishable by an incredible amount of prison time. But under questioning, especially from Justices Elena Kagan and Brett M. Kavanaugh, Wright acknowledged that other areas of federal law might be endangered if the court accepted his argument. One example, background checks that prevent those who are subject to protective orders from buying firearms, a law that Kavanaugh said had resulted in 75,000 gun purchasing denials in 25 years. Kagan seized on what she said were inconsistencies in Wright's defense of the Fifth Circuit ruling. I'll tell you the honest truth, Mr. Wright, Kagan said. I feel like you're running away from your argument, because the implications of your argument are just so untenable. Justices Neil M. Gorsuch and Amy Coney Barrett said a state judge had found a credible threat in Rahimi's case. The dangerousness argument seems most apparent there, Gorsuch said. Chief Justice John G. Roberts Jr. agreed. You don't have any doubt that your client's a dangerous person, do you? Roberts asked Wright. Your Honor, I would want to know what dangerous person means at the moment, the lawyer replied. Roberts responded, to laughter in the courtroom, well, it means someone who's shooting, If some justices on Tuesday suggested Wright's argument was too broad, the same was true of Prelogar's argument that the Second Amendment protected only law-abiding, responsible citizens. It can be irresponsible not to take out your recycling, Roberts said. Prelogar said she was only tracking the language the court had used in previous rulings, which included the description of law-abiding and responsible citizens. But she eventually acknowledged that dangerous could be an acceptable way to define not responsible in this context. Prelogar told the justices the government should be free to create some categories of people who are barred from possessing firearms, those convicted of violent crimes, for instance, or the mentally ill, without having to prove each individual was dangerous. Justice Ketanji Brown Jackson, who joined the court after the ruling in Bruin, said she was a little troubled by having a history and traditions test that also requires some sort of culling of the history so that only certain people's history counts. And she wondered how that test could apply in a modern context. Let's say I'm a legislator today in Maine, for example, and I'm very concerned about what has happened in that community, and my people, the constituents, are asking me to do something, she said to Prelogar, in reference to a mass killing in that state last month by a man whose threats and mental decline had been reported to local law enforcement. Do you read Bruin as step 1, being go to the archives and try to determine whether or not there's some historical analog for the kinds of legislation that I'm considering? Preloger said the test doesn't require a precise match of historical tradition to laws restricting gun possession by certain categories of people. In questioning Wright, Kagan said the current case pointed out such difficulties. 200 some years ago, the problem of domestic violence was conceived very differently, she said. People had a different understanding of the harm. People had a different understanding of the right of government to try to prevent the harm. People had different understandings with respect to pretty much every aspect of the problem. So, if you're looking for a ban on domestic violence, it's not going to be there. The case is United States versus Rahimi. Officers are on trial for Elijah McClain's death. Here's what to know. The second trial of a police officer in the death of Elijah McClain concluded Monday, acquitting the suspended Aurora police officer of all charges, nearly a month after a Colorado jury convicted one officer and acquitted another in the 23-year-old unarmed black man's fatal encounter with Aurora police in 2019. McClain's death galvanized protests against police brutality and racial injustice that swept the country in 2020 and spurred state and local policy changes for the kind of chokehold restraints and ketamine injections used during his arrest. Nathan Woodyard, 34, was charged with criminally negligent homicide and reckless manslaughter after he placed McClain in a carotid hold while trying to arrest him. The Colorado jury found him not guilty. The jury split its verdict in the case's first trial, convicting suspended Aurora police officer Randy Roedema, 41, of criminally negligent homicide and third-degree assault but acquitting fired officer Jason Rosenblatt, 34, of the same charges. A trial of the two responding paramedics is expected to begin this month. McClain was walking home from a convenience store near his apartment on the night of August 24, 2019, when he was detained by police responding to a 911 caller who reported the young massage therapist as looking sketchy. McClain was wearing a black ski mask because of a medical condition that made him cold, family said, and he was carrying a shopping bag when police approached. McClain was listening to music through headphones and didn't initially respond when officers called to him. They then tackled McClain before Woodyard placed him in a carotid hold. Responding paramedics injected him with ketamine, a powerful sedative. McClain never regained consciousness after the arrest and was taken off life support several days later. News of McClain's death remained mostly local for 8 months until George Floyd's murder by Minneapolis police in 2020 sparked scrutiny of cases in which unarmed black people were killed, including Breonna Taylor in Louisville and Ahmaud Arbery in suburban Georgia. Colorado Attorney General Phil Weiser, Democrat, in a 32-count indictment charged 5 Aurora first responders, Roedema, Rosenblatt, Woodyard and Aurora Fire Rescue paramedics Jeremy Cooper, 49, and Peter Sochiniak, 51, who jointly face trial later this month. All 5 defendants pleaded not guilty. What charges do the defendants face? The 5 defendants face charges of criminally negligent homicide and reckless manslaughter, plus other individual charges. Each of the defendants, except Woodyard, was also charged with second-degree assault, the most serious of the charges. The cases are expected to focus on which actions most directly contributed to McClain's death and on the defendant's state of mind. To meet the standard of recklessness, the prosecution must prove that the defendants knew their actions carried the risk of death when they engaged McClain, said Eric Johnson, a law professor at the University of Illinois College of Law who focuses on criminal law. The criminal negligence standard requires prosecutors only to show that the officer's failure to perceive the risk was a gross deviation from the standard of care, he said. Prosecutors also have the burden of proving that the acts in question, the restraint and the injection of ketamine, were a but-for cause of death, meaning that if the actions had not occurred, McClain would not have died. In this kind of case where you have multiple contributing factors, it can be hard to prove which factor was cause of death. Paramedics will claim it was the chokehold, and the cops will say it was the ketamine, Johnson said. Who is prosecuting the case? The Office of Weiser, the Colorado Attorney General, is handling the prosecution. Then Adams County District Attorney Dave Young declined to file charges in the weeks after McClain's death in 2019. Citing an initial autopsy report, he said he found no proof that the first responders caused McClain's death. After the murder of Floyd in Minneapolis brought renewed attention to McClain's death, Colorado Governor Jared Polis, Democrat, appointed Weiser to probe the case as a special prosecutor. Weiser said in 2021 that his office had the option to review Young's records on the case or convene a statewide grand jury to investigate. We decided to take the latter course because whenever a person dies after an encounter with law enforcement, the community deserves a thorough investigation, Weiser said at the time. Mr. McClain's family deserves it. And justice requires it. What are the defendants saying? The 5 defendants have mostly let their legal filings speak for them. In a filing last year, Woodyard asked that the case against him be dismissed, arguing that several medical experts who testified before the grand jury said McClain died of the effects of ketamine administered by paramedics, not Woodyard's carotid hold. A judge later struck that evidence and arguments, according to the Denver Gazette, which obtained the court filings meant to be under seal. Lawyers for Cooper and Suchiniak unsuccessfully filed petitions seeking dismissal. They argue that Weiser didn't have jurisdiction to bring charges after Young, the former Adams County District Attorney, declined to bring charges, citing the first autopsy report. An amended autopsy report was filed after more evidence, including body camera footage of the incident, came to light. The new report states that McClain died of complications of ketamine administration following forceful restraint, a boost for the prosecution's argument. Undermining the prosecutor's case is that the manner of death, for example, accident, homicide, suicide, remains undetermined. What took so long for the case to go to trial? McClain's 2019 death was initially written off by officials as a preventable tragedy, although local residents, including McClain's family, had questioned Aurora officials over the case. It wasn't until mid-2020, when racial justice protests swept the country, that public pressure forced officials to take another look at the death. Investigations of the police and first responder policies eventually led to the decision to put the matter before a grand jury, but jurors were unable to meet for months because of the coronavirus pandemic. In 2021, the grand jury returned the 32-count indictment against the 5 defendants. The amended autopsy report was later filed, citing evidence from the grand jury investigation. For the next year, the defendants argued over who was responsible for McClain's death and sought to separate their cases from one another. In January, a judge finally determined a division of the cases and set trial dates. What was the political fallout in Aurora? A wave of investigations and changes has washed over Aurora in the years since McClain's death and raised questions about the practices of mostly white suburban police departments such as Aurora's and the disproportionately high number of encounters their officers have with residents of color. In June 2020, Polis signed Colorado's police accountability law, which notably banned the use of chokeholds such as the one used on McClain. A month later, Aurora's interim police chief fired 3 officers who mocked McClain's death in a reenactment, including Rosenblatt, who responded in a text message of the photo with "haha." Aurora city leaders hired an independent civil rights lawyer to probe the McClain case and the Aurora Police Department. The Attorney General's office also launched a probe, which led to a 2021 report that found Aurora police have a pattern of racially biased policing and use of excessive force. The probe prompted the city, on behalf of its police department, to enter into a consent decree to reform its patterns and practices. Since McClain's death, Colorado has banned police chokeholds and limited the use of ketamine by paramedics during arrests. In late 2021, the city settled a civil rights lawsuit with McClain's family for $15 million, the largest in Colorado history. Ex-DOJ employee who testified against Fugees rapper sentenced. George Higginbotham testified against Fugees rapper Pras Michel in a criminal case arising from one of the world's biggest financial scandals. A former Justice Department employee was sentenced Tuesday to 3 months probation and ordered to forfeit $70,000 for his part in a sprawling international conspiracy that ensnared Fugees hip-hop band founder Pras Michel, former Donald Trump fundraiser Elliot Broidy, and Malaysian financier Low Taek Joe in the largest foreign embezzlement scheme ever charged by the United States. George Higginbotham, 51, was not as well known as his co-conspirators, but his guilty plea in November 2018 in a cooperation deal with prosecutors helped bring down the curtain on what he admitted in plea papers was an illegal attempt by Lowe to shut down U.S. civil and criminal investigations into his alleged theft starting in the late 2000s of $4.5 billion from Malaysia's sovereign wealth fund, known as 1MDB. A second failed prong of the plot allegedly led by Lowe, who remains at large, was to persuade Trump to extradite a wealthy Chinese national, Guo Wengui, a prominent critic of China's government then living in New York, to China at the direction of Beijing authorities, all in exchange for about $100 million. At a brief morning sentencing hearing in Washington, Higginbotham said he accepted unmitigated responsibility for his poor decisions and criminal conduct and apologized for the damage they caused the Justice Department and the people he loved. "I lied to myself every step of the way. I broke the law, and I have no excuses," Higginbotham told U.S. District Judge Colleen Kollar-Kotelly. At a time of a loss of faith in the Justice Department and government institutions, the Fordham Law School graduate turned to federal prosecutors saying, "I should have been working with them to maintain the integrity of our system, not hurting it." Higginbotham, who worked as a senior congressional affairs specialist for the Justice Department from July 2016 to August 2018, pleaded guilty on November 30, 2018, to one count of conspiracy to make false statements to a bank, and admitted to illicitly facilitating the transfer of tens of millions of dollars into the United States to finance the lobbying effort. Higginbotham admitted he attempted at Michel's direction to open accounts at U.S. financial institutions to funnel in Lowe's money, creating fake loan and consulting documents to deceive banks and regulators about the fund's true source and purpose. Prosecutors requested leniency and 3 months probation, saying Higginbotham was the first cooperator in the investigation, that he provided expansive and substantial assistance in securing the convictions of co-conspirators in multiple interviews for a year before his plea, and testified at Michel's trial in Washington this spring. The Grammy Award-winning musician awaits sentencing following his April conviction on 10 counts including money laundering, illegal lobbying, witness tampering and campaign finance violations, charges punishable by a statutory maximum of up to 20 years. In sentencing Higginbotham, Kollar-Kotelly noted that he received a fraction of the money paid to others, had no direct involvement in unlawful efforts to lobby U.S. officials, and was not the architect, engine or primary beneficiary of the plot, according to prosecutors. Michel kept about $80 million, Brody was paid $9 million, and his associate, business executive Nikki Molly Lum Davis, was paid almost $11 million. Brody and Davis separately pleaded guilty in 2020 to conspiring to violate the Foreign Agents Registration Act, known as FARA. Brody was pardoned by Trump on his last day in office. Davis was sentenced in January to 2 years in prison. Higginbotham, a former U.S. Agency for International Development employee who worked on vetting aid recipients on 4 continents, received $170,000, some of which was unrelated to the scheme. Still, Kollar-Kotelly said Higginbotham had a role in a serious offense of putting the interests of undeclared foreign principals above those of the United States. She said she credited him with his early acceptance of responsibility, cooperation, genuine remorse and a blemish-free 5 years spent under supervision since his guilty plea, as well as support from his family and ongoing employment despite the suspension of his law license. Those factors go a great deal from the court's perspective as to showing whether there's going to be deterrence in the future from Higginbotham committing future crimes. Kollar-Kotelly said. "I think there has been and will be deterrence," she said, "and the need for others to be deterred is very important as well." Testifying in fraud case, Trump clashes with judge and draws reprimands. New York, for years, Donald Trump has responded to investigations and governmental scrutiny with a mixture of bravado and combativeness, often lobbing his rhetoric across rally stages and social media. On Monday, though, the former president brought that bombast to a courtroom where government officials questioned him at length in a public setting. Testifying in a $250 million civil trial where he and his business are accused of a years-long fraud, Trump defended his company, lashed out at the case and his inquisitors, and clashed with the judge. "This is not a political rally," New York Supreme Court Justice Arthur Engoron said, urging one of Trump's attorneys to control him. "This is a courtroom. New York Attorney General Letitia James, Democrat, last year sued Trump, his adult sons, and their namesake company, accusing them of dramatically inflating the values of real estate properties to get better financial terms with banks and insurers. Engoron already ruled before the trial that Trump and his company broadly committed fraud. He is hearing the case without a jury and will determine whether specific illegal acts occurred in the process and decide any potential penalties. Trump, the leading candidate for the Republican presidential nomination next year, has repeatedly assailed James's case, denied any wrongdoing and insisted that he is being targeted for political reasons. Testifying for hours Monday, he delivered often extended, meandering remarks, touting his business acumen and slamming the judge. He ruled against me without knowing anything about me. He ruled against me and said I was a fraud before he knew anything about me, Trump testified, raising his voice. The fraud is on the court, not on me. James is seeking to have Trump and his business pay at least $250 million in penalties and wants them blocked from doing business in New York State. Trump is also separately facing a whirlwind of legal peril, with criminal cases pending against him in New York, Florida, Georgia, and Washington. He has said repeatedly that all of these cases are meant to damage him electorally. James's lawsuit has plainly irritated Trump, who has long promoted himself as a successful businessman. He has been under no obligation to attend the trial since it began last month, except for his testimony, but he has shown up in person several times and criticized James and the lawsuit. In her lawsuit, James alleged that Trump and his executives knowingly misstated the values of their assets along with other data points, such as the square footage of properties. James and her team say Trump and the company inflated these figures in financial statements submitted to banks and insurance companies over multiple years. Trump's side has argued that no fraud took place and that real estate valuations are subjective. His attorneys also argued that lenders did not rely on these statements. Before Trump's testimony began, James told reporters she was certain that he will engage in name-calling and taunts on the stand. She also pointed to a core issue in the trial, saying Trump has repeatedly and consistently misrepresented and inflated the value of his assets. Trump also spoke to reporters before going into the courtroom, criticizing James again and insisting that he was facing political attack ads by the Biden administration. Trump's adult sons, who are also defendants in the case, testified last week in the trial, and both sought to distance themselves from the financial statements, saying they trusted the company accountants who assembled them using information provided by the company. They are expected to be called to testify again by their own attorneys later in the case. Ivanka Trump, one of their sisters, who was dismissed as a defendant over the summer, is scheduled to testify Wednesday. During his testimony Monday, the senior Trump cycled through a range of expressions and behaviors. He alternately appeared boastful and frustrated, proud and irritated, bored and distracted. His tangents and remarks often hewed to by now familiar topics. He talked about his luxurious properties, described how good a company I built and repeatedly defended his net worth. While questioned by Kevin Wallace, an attorney with James's office, Trump said his net worth was far greater than the financial statements, so I don't know what you're getting at, but go ahead. At another point, he maintained that his wealth was higher than what was reported in the financial statements because his accountants did not factor in his brand value. I became president because of my brand, Trump testified. Trump has answered questions in the case before, albeit not publicly. In April, he was deposed by James's office, and he said his financial statements come with disclaimers that other people might come to different conclusions about the value of his assets. During his deposition and on the witness stand Monday, Trump argued that disclaimers included by his accountants were a signal to lenders that they should do their own evaluations. On Monday, Trump repeatedly said that even if the statements were problematic, he was insulated from blame. I think the statements of financial condition were very good, were actually somewhat conservative and in some cases very conservative, he said. But regardless, he said, he's totally protected by the disclaimer clause that warned banks to go out and do your due diligence and to do their own analysis. His testimony also included courtroom insults aimed at James, such as a remark accusing her of watching every little move he made on the stand. Trump's appearance on the witness stand also included numerous rebukes from Engoron, beginning within 10 minutes of the start of his testimony. Trump quickly began complaining about the Democratic law enforcement officials who have investigated him. Engoron told Trump to refrain from making extraneous comments and just answer the questions, no speeches. Trump grumbled at one point that Engoron was ruling against me, because he always rules against me. Following another diatribe from Trump, the judge encouraged Christopher Kise, one of his attorneys, to have a talk with Trump about his behavior. "Mr. Kise, can you control your client?" he asked. Kise pushed back, though, saying that the former and again soon-to-be commander-in-chief understood the rules of a courtroom and did not need further instruction. Engoron later suggested he might remove Trump from the stand if he could not answer questions directly. He then raised his voice while addressing Trump's attorneys, who had stood up to argue that Trump should be able to make his case without restriction. Kise repeatedly called it a unique situation and asked for Trump to have leeway in speaking. His voice booming through the courtroom, Engoron told them to sit down. Soon after, Trump said from the stand, "This is a very unfair trial. Very, very. And I hope the public is watching." Engoron also seemed to needle Trump on Monday. Trump had complained about the judge's pretrial ruling, and Engoron said Trump should read my opinion again before adding, or for the first time, perhaps. "You're wrong in the opinion," Trump responded. "It is rare for a defendant to criticize a judge from the witness stand," said Chris Mate, an attorney from the firm Koskoff and Bieder. Mate represented the parents of children slain in the Sandy Hook massacre in a defamation lawsuit they filed against Alex Jones. In that case, Jones also repeatedly belittled the judge and the case outside the courthouse and online. "Jones and Trump were both playing to an audience," Mate said. "Their objectives are different than a normal defendant. A normal defendant would be doing everything he or she could do to avoid the legal penalty. Most judges aren't likely to be influenced either way by such attacks," Mate said. "Judges," he said, "really are required to set aside any personal feelings they may have and do their jobs." The jousting with the judge should not help his legal case, said New York University law professor Marcel Cahan. "It may hurt it if the judge feels that Trump is not answering the questions or not answering them truthfully. Whether it helps him politically is of course a different issue." Trump has already run afoul of Engoron, who last month issued a limited gag order blocking him from commenting on the judge's staff. That came after Trump posted on social media about the judge's law clerk and included a photo. Engoron has twice fined Trump for violating his order, for a total of $15,000. On October 25, he unexpectedly summoned Trump to the witness stand to explain some of his comments. After Trump was on the stand for a few minutes, Engoron promptly said he did not find him credible and fined him $10,000. Trump finished his testimony Monday afternoon, and his attorneys did not cross-examine him. After his testimony, James spoke to reporters and said Trump rambled and hurled insults. "But we expected that," she said. At the end of the day, the documentary evidence demonstrated that in fact, he falsely inflated his assets to basically enrich himself and his family. He continued to persistently engage in fraud. The numbers don't lie. Kise also spoke to reporters, saying the former president told everyone the facts, while Trump dismissed the case as a scam and defended his business practices after leaving the courtroom. "Everything we did was absolutely right," Trump said. Berman and O'Connell reported from Washington. Megan Vasquez in Washington contributed to this report. Trump and media want a televised trial in D.C. The Justice Department doesn't. The DOJ formally opposed a request to make the historic trial of a former president the first time federal courts allow TV cameras to broadcast or record a criminal trial. The Justice Department formally urged a federal judge Friday to reject calls by news organizations and by former President Donald Trump's defense to allow live television coverage of his federal trial in March on charges of illegally conspiring to subvert the results of the 2020 election, joining a potentially historic legal battle over public access to the federal courts. Last month, lawyers for a coalition of news organizations including The Washington Post and for the corporate parent of NBC News filed 2 petitions in Washington asking U.S. District Judge Tanya S. Chutkan to make an exception to the long-standing rule barring cameras from federal courtrooms for Trump's case and to permit the televising, recording, or same-day release of video and audio recordings of his trial. "Since the founding of our nation, we have never had a criminal case where securing the public's confidence will be more important than with United States versus Donald J. Trump," attorneys for the 20-member News Coalition wrote in an October 5 application. They asserted that the trial of a former president and presumptive 2024 presidential nominee on charges of obstructing the most recent election presents the strongest possible circumstances for continuous public oversight of the justice system. In a separate sworn statement supporting NBC's request, Rebecca Blumenstein, the president of editorial for NBC News, urged the video recording of Trump's proceedings for posterity, saying, "It would be a great loss if future generations of Americans were forever deprived of being able to access and view the events of this trial even years after the verdict, which would immeasurably improve the ability of future journalists and historians to retell accurately and meaningfully analyze this unique chapter of American history." Trump's defense took no position on the media's request to the court, but his attorney John Lauro repeatedly called for the election subversion case to be televised before and after Trump's indictment, adding in a Fox News interview, "And I would hope the Department of Justice would join in that effort so that we take the curtain away and all Americans get to see what's happening." Ordered by Chutkan to respond by Friday, prosecutors with special counsel Jack Smith said that the court's hands were tied, arguing that the media applicant's proposal is clearly foreclosed under Rule 53 of the Federal Rules of Criminal Procedure, which prohibits the broadcasting of judicial proceedings from the courtroom. Courts have long upheld the rule's constitutionality, and the federal judiciary reaffirmed the policy in criminal cases as recently as September. Assistant Special Counsels James I. Pierce and John M. Pelletieri wrote in an 18-page filing for the Justice Department, adding, "Whatever policy the applicants believe supports their requested relief is not properly directed to the court. This court should deny the applications." Since the dawn of the television age, federal courts have prohibited cameras in the courtroom, wary of feeding what the Supreme Court called in a landmark 1966 decision a carnival atmosphere of publicity that could intimidate witnesses, sway jurors, prompt grandstanding by attorneys or judges or deprive criminal defendants of their due process rights. That fear was exacerbated nearly 3 decades ago by the 9-month televised criminal trial and acquittal of retired football star O.J. Simpson on state murder charges in California. But leaps in technology, the recent coronavirus pandemic emergency and increasing experimentation by federal courts with live or recorded streaming of oral arguments have led some lawmakers and advocates to ask whether Trump's case might mark a fresh tipping point in the debate, or at least provide the impetus for incremental changes such as the archiving of video or the prompt release of audio recordings. I have my skepticisms about whether these courtroom camera efforts can prevail, but it is also unquestionably the case that the argument for cameras here is at its all-time strongest. University of Utah law professor Rommel Anderson Jones wrote in an email, adding, "It is hard to imagine any case or any defendant in the whole history of our federal courts that is as central to the public interest as this one." Jones said traditional concerns about creating a circus atmosphere or causing problems for witnesses or defendants can be addressed by limiting access to one camera or releasing footage after court approval. Audio streaming, she said, although it would rob the audience of the key visual cues and still give rise to misinformation-laden disputes about interpretation, would be another option that would at least give the general public more concrete information about what is happening. Trump has pleaded not guilty to an August 1 indictment accusing him of a criminal conspiracy to remain in office, obstruct Congress's lawful certification of Joe Biden's victory and deprive Americans of their civil right to have their votes counted. The case is one of 4 felony prosecutions launched this year against Trump. They include similar allegations by Georgia officials of trying to obstruct that state's election results. He also has been federally indicted in Florida over his alleged retention and mishandling of classified documents and obstruction after leaving the White House, and is accused in New York State of business fraud and covering up a hush money payment made during the 2016 election campaign. Trump's federal cases both fall under the rule barring televised courtroom proceedings. New York state courts have a similar ban, although acting New York Supreme Court Justice Juan M. Merchan permitted photographers to record still images before Trump's arraignment in April, over Trump's objections. By contrast, Trump's Georgia court is expected to permit telecasting of his trial, and it streams all hearings on the court's YouTube channel and permits a pooled news television camera in the courtroom. The News Media Coalition pointed out that Trump's Senate impeachment trial after the January 6, 2021, attack on the U.S. Capitol and hearings of the House Select Committee that investigated events surrounding the rioting were both nationally televised, drawing opening day television audiences averaging more than 11 million and 20 million, respectively, not counting online viewers. A legal team led by Charles D. Tobin, of the Ballard Spahr law firm, argued in a letter to the federal judiciary that with Trump himself campaigning for the presidency by claiming that his criminal prosecutions are election interference by prosecutors, allowing the public to see for itself would alleviate, not intensify, challenges to the legitimacy of the rule of law. If Americans do not have confidence that Mr. Trump is being treated fairly by the justice system, there is a very real chance they will reject the verdict, whatever it is, and that their faith in democracy and our institutions will be further diminished, Tobin and attorney Leda Walker wrote. Recent and painful events in our nation's capital show that, taken to an extreme, this sort of doubt and cynicism can lead to violence. Trump and the news media are not alone in seeking to speed change in the federal judiciary. Dozens of Democratic lawmakers and a spokesperson for the Republican-led House Judiciary Committee have said they support cameras in court in the limited but extraordinary circumstance of Trump's election obstruction case, and the full House has voted in the past for such changes. A bipartisan group of senators also introduced legislation this year before Trump's federal indictments to grant federal judges discretion to allow cameras while protecting the identities of witnesses and jurors. If the public is to fully accept the outcome, it will be vitally important for it to witness, as directly as possible, how the trials are conducted, the strength of the evidence adduced and the credibility of witnesses, Representative Adam B. Schiff, Democrat, California, wrote to the federal judiciary in August in regard to Trump's case. The pandemic did usher in revolutionary changes in federal and state courts, which were compelled to adopt live streaming because of pandemic restrictions on indoor gatherings that affected jurors, attorneys, court staffers, and the public. The Supreme Court began live streaming audio of oral arguments, and all federal appellate courts, including the one in D.C., make audio of oral arguments available online. Under since expired federal pandemic emergency legislation, U.S. trial courts around the country also allowed federal criminal proceedings to take place by video or audio conferencing, with many allowing the public to access the proceedings by phone or online. In a milestone proceeding, the televised state trial of former Minneapolis police officer Derek Chauvin, who was found guilty of murder and manslaughter in the death of George Floyd, won praise from many past critics of the exclusionary practice. The Minnesota Supreme Court afterward granted all district courts in that state broad discretion to allow video coverage of most criminal trials. Even hardcore opponents became converts. Jane E. Kirtley, a professor of media ethics and law at the University of Minnesota, wrote in an email. Yet, Kirtley said, while it was her sincere hope that U.S. courts would go along at least with audio live streaming, I cannot be optimistic, given the federal judiciary's implacable and long-standing opposition. Judges don't like to give up control, and they see cameras in the court as the camel's nose under the tent, she said. The Federal District Court in Washington, no stranger to high-profile cases, for nearly 2 decades has offered live closed-circuit transmission of video taken from the courthouse's own cameras to nearby overflow rooms used by the public and media to permit electronic note-taking and live written and online reporting, but not recording or rebroadcast, showing that changes are possible. Still, advocates face an uphill fight. On October 26, a rulemaking panel of the national policymaking body for the federal courts denied the request by Media Coalition lawyers to exempt Trump's case from Rule 53. An advisory panel to the Federal Judicial Conference found it has no authority to grant exceptions to clear-cut rules, as first reported by Politico. But the panel agreed to create a subcommittee to consider a future rule change that would allow exceptions in extraordinary cases or at a judge's discretion. Changing a rule under a process set by federal law generally takes 3 years and requires public comment and the approval of the panel, the full conference of federal judges, the U.S. Supreme Court and Congress. This article has been updated to reflect that while Trump's attorney in interviews has called for his trial to be televised, prosecutors in their Friday motion stated that his defense requested that they convey that it took no position on the media request to the court. Live updates, analysis, key moments from Republican presidential debate. We're live from the Washington Post newsroom with a group of reporters sharing our insights about what you're seeing on stage tonight in Miami. 5 presidential candidates are on stage. Once again, former President Donald Trump, the polling frontrunner, is skipping the showdown. Former New Jersey Governor Chris Christie, Florida Governor Ron DeSantis, former UN Ambassador Nikki Haley, tech entrepreneur Vivek Ramaswamy and Senator Tim Scott of South Carolina all met tighter criteria than last time established by the Republican National Committee. Trump once again planned some counter-programming, a rally in nearby Hialeah, Florida, which is heavily Hispanic. Here's what to know. The 2-hour debate started at 8 p.m. Eastern. Moderators included NBC's Lester Holt and Kristen Welker, as well as Salem Radio Network talk show host Hugh Hewitt. The event aired on NBC's television and digital platforms and also streamed on Rumble. North Dakota Governor Doug Burgum did not make the stage after he failed to meet the polling and fundraising criteria set by the RNC. Former Arkansas Governor Asa Hutchinson also did not qualify. Former Vice President Mike Pence suspended his campaign since the last debate in September. 5 things to watch for in the third Republican debate, including how tough the candidates get on Trump in his absence. A comparison of where the 2024 presidential candidates stand on key issues. Colorado judge weighs if Trump incited an insurrection, can run again. Denver, a Colorado judge is weighing whether Donald Trump incited an insurrection and is barred from running for president again. During a hearing this week, she has heard about 19th-century constitutional debates, how and when the National Guard is deployed, free speech rights and jokes cracked by Trump advisors about the January 6, 2021, attack on the U.S. Capitol. The case, one of many challenging Trump's ability to serve under an 1868 provision of the Constitution, stands out because the judge overseeing it is holding an unusual week-long trial to help make up her mind. She has heard from constitutional scholars, police officers who were assaulted on January 6, members of Congress and Trump advisors who met with the outgoing president days before the riot. The hearing is expected to conclude Friday, and Denver District Judge Sarah B. Wallace is expected to rule this month, as cases in other states move along briskly. On Monday, Trump filed a lawsuit in Michigan after a judge declined to let him intervene in a case seeking to prevent him from appearing on the ballot there. On Wednesday, a federal judge threw out a challenge in New Hampshire. And on Thursday, the Minnesota Supreme Court heard arguments over his ability to run there. All of the cases center on Section 3 of the 14th Amendment, which bans people from holding office if they engaged in an insurrection after swearing an oath to the Constitution. It was ratified 3 years after the Civil War ended to prevent Confederates from holding office. The lawsuits argue that Trump incited armed supporters to attack the Capitol to prevent Congress from certifying Joe Biden's victory. Trump's attorneys contended he did not inspire or participate in an insurrection, and they summoned his former advisors to the stand to testify. Trump wanted 10,000 or more National Guard members in Washington on January 6 to guarantee the protest was peaceful. Kash Patel, who served as Chief of Staff to Acting Defense Secretary Christopher C. Miller, testified Wednesday that Trump authorized 10,000 to 20,000 National Guard members to assist law enforcement days before the January 6 attack. About 340 were deployed that day to assist with traffic control and other minor tasks, but more weren't sent because local authorities did not ask for further assistance, Patel testified. Absent those requests, we were under the advisement of our legal offices, counsels that we could not activate the National Guard, Patel said. His comments were at odds with testimony a day earlier from Syracuse University law professor William Banks, an expert on national security and counterterrorism. Banks testified that Trump as president had broad powers to send the D.C. National Guard, FBI, Secret Service, Department of Homeland Security and other law enforcement agencies to the Capitol to help quell the violence without authorization from anyone else. He would need no request or permission from anyone else, Banks said of Trump's ability to send the D.C. National Guard. Banks said there was nothing in the public record showing Trump had authorized thousands of National Guard troops. He noted the president commands the D.C. National Guard and said he should have deployed troops by early afternoon, as soon as he learned of the violence at the Capitol. Trump did not act for hours. Former Trump spokeswoman Katrina Pearson said she was brought in to help with the January 6 rally a few days beforehand because of infighting among the organizers. She said Trump told her at a January 4 meeting that he wanted 10,000 National Guard members present to prevent problems. He goes, "Let's just have 10,000 National Guard and then that way we won't have any problems," she testified. On cross-examination, lawyer Eric Olson displayed a copy of text messages between Pearson and Max L. Miller, who was a Trump aide at the time and was elected to Congress last year. In one message after the Trump meeting, Miller told Pearson that he was just glad we killed the National Guard and a procession. Pearson reacted to the comment with a heart emoji. In another message, Pearson made light of the attack on the Capitol less than 24 hours after it happened by sending Miller a photo of a rioter hauling the lectern for then-House Speaker Nancy Pelosi, Democrat, California, through a hallway. "You have to admit that seeing Nancy Pelosi's lectern being carried away by a Trump supporter is pretty damn funny," she wrote. Asked on the stand about the message Wednesday, Pearson said, "Yes, it was hysterical." Amy Kramer, chairwoman of Women for America First and one of the organizers of the January 6 rally on the Ellipse, testified Thursday that the crowd that had gathered to hear the president was peaceful and upbeat. She called them patriotic, freedom-loving Americans. "It was just a happy, joyful occasion, and you could see it on people's faces," she testified. Later, lawyers for those bringing the lawsuit showed a video of Trump urging his supporters to march to the Capitol and some in the crowd soon after yelling, "Invade the Capitol." Kramer said she had never seen the video before and said those who attacked the Capitol were not patriotic. Those bringing the lawsuit have dedicated part of the week to arguing that January 6 qualified as an insurrection. Gerard Magliosa, an Indiana University law professor who has studied the 14th Amendment, cited an 1828 dictionary to show that insurrection was defined at the time as rising against civil or political authority and the open and active opposition of a number of persons to the execution of law in a city or state. Members of Congress in the 1860s believed that a person did not have to take up arms to participate in an insurrection and that speech alone could qualify one as an insurrectionist, he said. Magliosa noted that Congress declined to seat one member because he had written a letter to the editor in support of the Confederacy and another because he had given $100 to his son before he joined the Confederacy. Trump's attorneys called Representative Ken Buck, Republican, Colorado, to the stand Thursday as they sought to show the House's report on the Capitol attack was incomplete. Buck testified that the committee overseeing the investigation did not include all perspectives and didn't explore some aspects of the decision not to deploy more National Guard members. In disparaging the attack on the Capitol, Buck also provided testimony that could prove helpful to those bringing the lawsuit. "I thought what happened on January 6 was obviously bad," Buck testified. "It was a riot in the Capitol building. It was meant to disturb a proceeding." Buck's description of what happened on January 6 resembles the definition of insurrection that Magliosa said was used at the time the 14th Amendment was adopted. Buck took the stand a day after announcing he would not seek re-election in a video that said too many Republican leaders are lying to America. Trump welcomed his departure, calling him weak and ineffective even though he is using his testimony to try to get on the ballot in Colorado. In an interview, Buck said he was testifying to keep Trump on the ballot because I'm a Constitution guy. Peter Simi, an associate professor of sociology at Chapman University who has studied political extremism, testified that Trump's far-right supporters viewed Trump's January 6 speech as a call to violence because he repeatedly said they needed to fight and were at risk of losing their country. During that speech, Trump also said they should peacefully and patriotically protest. Simi said extremists put little stock in that comment, in part because Trump put far more attention on fighting than acting peacefully. In far-right extremist culture, fighting is to be taken literally, he said. Trump attorney Scott Gessler downplayed the use of the word fight, noting that the phrase is commonly used by politicians. He played a montage of Pelosi, Vice President Harris, and other high-profile Democrats telling their supporters to fight. On Thursday, the Minnesota Supreme Court heard arguments in a similar case. Justices asked pointed questions about whether states should be wading into this debate or if this was a question best left for Congress. Throughout the hearing, which lasted about 90 minutes, they noted the 14th Amendment's clause on insurrection does not specifically state whether it applies to the presidency, and they debated what constituted involvement in a rebellion against the Constitution. Chief Justice Natalie E. Hudson said she was concerned about the prospect of creating just chaos if the question is decided differently by various states. You have the potentiality of 50 different states, depending on the nature of the statutes in those states, deciding this question differently, deciding whether states have the right to determine who's eligible for national office, and that concerns me, she said. Ron Fine, an attorney for the voters who brought the lawsuit with the help of the group Free Speech for People, said it was the duty of the court to answer the eligibility question. Nicholas Nelson, a lawyer for Trump, said the question was political, not judicial. In another case, a federal judge on Wednesday threw out a challenge to Trump's candidacy in New Hampshire brought by John Anthony Castro, a self-described longshot Republican candidate for president who is bringing a slew of lawsuits trying to bounce Trump from the ballot state by state. Judge Joseph N. LaPlante dismissed the New Hampshire case, writing that Castro didn't have the authority to bring the lawsuit because he wasn't actively campaigning for president and has not provided any evidence suggesting that he has voters or contributors in New Hampshire or anywhere else. What's more, the judge ruled that Congress and presidential electors, not courts, are the ones to determine whether candidates are eligible to serve as president. The cases across the country are moving relatively quickly because states will begin holding caucuses and primaries in January. If any state knocks Trump off the ballot, the U.S. Supreme Court is expected to weigh in and resolve the issue for all states. Sanchez reported from Phoenix. Lee and Caldwell in Washington contributed to this report.